In the Karen Reed case, whatever happened to her habeas corpus petition? And Michael Proctor, his wife, stands by her man.
With all those disgusting text messages, is Mrs. Proctor really going to stand by her man? I'm Lainey Law.
And I'm attorney Andrew Myers.
It sounds like we have a messy episode ahead of us today.
Well, yeah, that's an old country song, Stand By Your Man. And Mrs. Proctor, Michael Proctor's wife, is certainly doing that as his disciplinary hearings have ended after 3 hearings spread out over 3 months. But no drum roll because we don't know what's going to happen. They've 3 officers in charge of the whole thing have taken it under advisement. But to top the whole thing off in this episode, Karen Reed's habeas corpus petition was not allowed. It was disallowed this week. And the court did a quite lengthy analysis. Here it is. And it goes on for 28 pages.
Short and sweet.
And the federal court, as it is wont to do, gave a great deal of background. And, our viewers know all of this, so we're not going to go over the entire. Federal courts are very picky over facts and especially over procedure and especially over whether they have jurisdiction or not, because the federal courts are courts of limited jurisdiction. Everybody thinks, it went to the feds. That's a big deal. It is a big deal. And I'm not saying that it's not, but they always pay a lot of attention to whether they even have jurisdiction. So we jump down to here that our analysis starts here where the federal court in Boston says the Supreme Judicial Court held that because the jury did not publicly affirm that Karen Reed was not guilty of counts 1 and 3, there was no acquittal, barring retrial under the double jeopardy clause. So that's where our analysis starts and ends here today. And here's the analysis. Here's, federal courts always have to look at the jurisdiction, whether they even have it. And they go on for pages. The primary relief petitioner Karen Reed seeks is release from state custody and a declaration that a retrial on counts 1 and 3 would violate the double jeopardy clause. In effect, she seeks a permanent stay of her state prosecution. That request for relief potentially conflicts with the policy that, except under extraordinary circumstances, where the danger of irreparable loss is both great and immediate, federal courts should abstain from enjoining state criminal prosecutions or issuing declaratory or other relief to similar practical effect. So, what the court is confirming, as I pointed out before, is that they are courts of limited jurisdiction.
I need to interject. Can you scroll back up real quick?
Yeah.
What would be considered irreparable losses, both great and immediate? Because wouldn't the amount of money being spent on all these attorneys, whether it's the defense or the prosecution, is money just hundreds of thousands of dollars? That's not irreparable.
No, because the habeas corpus petition, the whole idea is that they've got a hold of her body, and they did the analysis that yes, she's free on bail, but she's still under the constraints and the orders of the court. So in essence, the state courts still have control of her if she's on bail. So if she missteps, if she doesn't conform, I should say, to all of the conditions of her bail, they could nab her. And believe me, that there are people watching her all the time. And if she oversteps what she is constrained to do and not do, the state is still in control of her body. So no, the money doesn't matter here. Money matters everywhere else in the world, but not here. They could care less. We've already heard allegedly that her legal tab is up to $5 million.
If she, for example, is found not guilty, would she then be eligible to sue the state and
Absolutely.
Okay, so
it's happened.
Okay.
It has happened. That's a whole nother can of worms with a whole nother bunch of analysis. But here's what the federal court went on to say. A federal court generally must abstain from acting if the requested relief would interfere with an ongoing state judicial proceeding. See, they're paying attention to the state and saying, in this limited circumstance, we take a back seat to the state's proceeding. That's condition 1. Condition 2, that implicates an important state interest. And 3, that provides an adequate opportunity for the federal plaintiff to advance his federal constitutional challenge, such as a state criminal prosecution. But if there is a showing of bad faith, harassment, or some other extraordinary circumstance that would make abstention inappropriate, a federal court may enjoin or effectively enjoin an ongoing state proceeding. And so, our supporters of Karen Reed are going to say, this is extraordinary. Here, petitioner makes a colorable double jury claim. So what they're saying is, we don't have to listen to this if we don't want to. Under federalism, we can step back and just let the state courts do what they do. But at least on the face, on the papers, there is enough for us to keep going, to continue. Even if she is ultimately acquitted of counts 1 and 3, or if a conviction on those counts is ultimately overturned on double jeopardy grounds, she will have suffered irreparable injury from standing trial again for those charges. The court, therefore, will not abstain and will consider the merits of petitioner's claim. So here we are on page 11, and we didn't go over all the intricacies because it's very interesting if you are a constitutional law, a criminal law, or even a civil law procedure maven. But you can go back and read those 11 pages. We're going to keep going. We all know what double jeopardy is. We've talked about it. Does it apply here? We have explicitly held that a trial judge declaring a mistrial is not required to make explicit findings of manifest necessity, nor to articulate on the record all of the factors which informed the deliberate exercise of his, let's say her, discretion. And we have never required a trial judge before declaring a mistrial based on jury deadlock to force the jury to deliberate for a minimum period of time, to question the jurors individually, to consult with or obtain the consent of either the prosecutor or defense counsel, to issue a supplemental jury instruction, or to consider any other means of breaking the impasse. So do you kind of hear where they're going here? They're kind of saying, they don't have to make the explicit findings of manifest necessity. And in this case, as you know, all of that happened pretty quickly, remember?
Mm-hmm. Well, I mean, that's the biggest argument, or one of the bigger arguments that we're having, is that it happened so quick that they didn't even have a chance to argue against it.
And we're going to get to that in just a minute. Similarly, the First Circuit, and we're in the First Circuit here in Massachusetts, the First Circuit has held that trial judges are not required, quote, to take specific steps or make specific findings before concluding that a jury is deadlocked and unlikely to reach a verdict. Here, there was a manifest necessity for the declaration of mistrial based on jury deadlock, and the trial court did not abuse its broad discretion in reaching that conclusion. You can almost hear the court cracking a beer at this point. I'll take it back. I didn't say that. The SJC similarly concluded that the jury clearly stated during deliberations that they had not reached a unanimous verdict on any of the charges and could not do so. The first and second notes, remember the notes that the jury kept sending up to the court? We can't reach a verdict. We're at an impasse. There were 3 of them. Well, here the U.S. District Court in Boston is saying the first and second notes provided no indication of even a partial consensus, and the third note plainly implied.
Plainly implied. I like that description.
Those two words
plainly implied.
Yeah, those two words really don't fit together, do they? It's kind of like saying dark light. Plainly implied the opposite. In short, the record before who am I to criticize the language of a federal court? I mean, I barely made it through grammar, as people have pointed out down in the comments. In short, the record before the trial judge suggested complete deadlock. The court sees no basis to conclude that the trial judge's discretion to declare a mistrial was incorrect or improper. So, as for counsel's opportunity to respond to the third note, it is true. Now, this is what you were talking about before, that it happened so quickly. And, in the pleadings to the Massachusetts Supreme Judicial Court, they actually put down in the bottom of the document, in the footnote, here's where you can go on YouTube to see what happened as soon as the jury said we can't do it. As for counsel's opportunity to respond to the third note, it is true that the span of time was relatively brief between the point that the trial judge advised counsel that the jury was at an impasse and the point she declared a mistrial. But there's always a but, isn't there? But it was not so brief that counsel could not have objected or asked to be heard. Furthermore, after the trial judge declared a mistrial, there is no obvious reason why counsel could not have immediately asked to be heard at sidebar in order to seek reconsideration of her decision before the jury was formally discharged. And this, I don't know, I have a little bit of a problem with this. I mean, people, when I criticized the Supreme Judicial Court decision, people said down in our comment section, who are you to question 7 Supreme Court judges in Massachusetts? Who are you? Who do you think you are? Well, I have a First Amendment right, like everyone else. Everybody has an opinion, and my opinion is that I guess technically they're right, but there really was no time. But from the time that Judge Cannoni read that third note, she just said, I'm not going to do that to you. I'm going to declare a mistrial. And people say, well, and in fact, she said in her memorandum, she said, Karen Reed's defense attorneys never showed themselves to be shrinking violets. Remember that?
The shrinking violets was crazy.
But on the other hand, she has scolded them. She's made them stand up one by one. Do you understand this? Do you understand that? And she's been very quick to point out her issues with Karen Reed's defense attorneys. And so this part here is really subject to objective questioning. Furthermore, after the trial judge declared a mistrial, there is no obvious reason why counsel could not have immediately asked to be heard at sidebar in order to seek reconsideration of her decision before the jury was formally discharged. Well, all right, that's the finding of the court. They're the federal court. Nothing more was required as a matter of federal constitutional law before the trial judge could fairly conclude that the jury was genuinely deadlocked and should be discharged. In particular, the trial judge was not required to inquire about a possible partial verdict or poll the jury before discharging it. As the SJC noted, to make further inquiry would create a substantial possibility of coercing a verdict. Here's the part that we've discussed before under Rule 27 of Massachusetts Criminal Procedure. A judge is told that in a multi-count case indictment, the judge may inquire into the jury. It doesn't say she must, but if you go down into the notes of that particular rule, you do find that there's more mandatory language. And it would seem, if they're paying attention up on Beacon Hill, that someone somewhere somehow should possibly consider either rewriting the statute or rewriting the rules, or
especially with technology. I mean, ultimately, the technology exists where theoretically, when the jury is deliberating, that they could just all anonymously and electronically submit their answers, have it linked to them, and then if it comes up that the verdict's not correct, then they go and deliberate on that verdict until it gets figured out. It doesn't have to be this hard. Like, technology is improving. We can send them emails, we can send them text messages if there's issues and we need to go back and check on them. It's not like how it used to be before, where it's like, how we're going to get these people, like we got to get them on horses or something. We have the technology that these juries should be easily accessible. So I agree with you that it should be updated.
Yeah. So like I always say, the really good stuff is in the footnotes. And this court is pointing to a federal decision, Toribio versus Lugo, and I'm sure I pronounced it wrong, so don't jump all over me for that. The trial judge ruled that defense counsel had consented to the declaration of a mistrial because she failed to make an objection. So they're saying there's federal precedent here, like it or not, that failing to make an objection really is consent. The First Circuit reversed, noting that counsel had made either 2 or 3 attempts to be heard during the district court's sua sponte consideration of whether or not to declare a mistrial, but that the judge stopped counsel in her tracks, cutting her off on each occasion. And it was only after these 3 attempts to state her position had been firmly rebuffed that she lapsed into silence. That is very far from the situation here, where defense counsel made no attempt to make an objection or ask to be heard. Again, I have a problem with this because, the judge's demeanor towards the defense is what it is, and it would have required them to jump up and down and interrupt her and incur the wrath, the absolute wrath that they've gotten many times during that case. So a lot of this is in nuance. A lot of this is in just, the dynamics of what happened during that trial, the dynamics and the relationships between the people in that case. So I hate to say this, but I'll say it anyhow. It seems like this is a case where you can jump to a conclusion and then find law to back you up. But this is it. It has long been settled under the Fifth Amendment that a verdict of acquittal is final, ending a defendant's jeopardy, and is a bar to subsequent prosecution for the same offense. But that's not to happen here. Here, the Supreme Judicial Court summarized what constitutes a valid jury verdict under the operation of Massachusetts law. And we get back to this. The fundamental requirements for a jury's issuance of a verdict in a criminal case are set forth in Mass Rule of Criminal Procedure 27A. Pursuant to that rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court. Our case law confirms that a criminal verdict is effective only when affirmed by jurors in open court. So this gets back to, remember last summer, this gets all the way back to what we were talking about last summer. And the court is saying it's not just form, it is a requirement. And Karen Reed's attorney's argument was, no, the substance overrules the form. I mean, here we have notes from jurors. We have one of the jurors going online. We have 5 different jurors, A, B, C, D, and E, saying it was unanimous on counts 1 and 3. And that overrides that substance of her having been acquitted of counts 1 and 3, count 1 notably being second-degree M. It's double jeopardy to put her in front of a jury again and a judge. But the federal court is saying, nuh-uh, the substance is, the form is the substance.
Well, under the notes that the jury put out, it just almost makes it sound like they just had bad jury instructions that they weren't really understanding or clear on, because that shouldn't have happened. If, why are they all speaking out now? It seems unlikely that multiple people would be speaking out like this if it weren't true. So something in the pipeline went wrong when they were making these decisions in the first place.
That was one of my takeaways from watching the 3-hour interview of juror Ronnie, who's now after Turtle Boy made him famous in a 3-hour-long interview on a Saturday night. Now all the Boston TV stations are grabbing onto the train, and now they're interviewing. And Vinny Politan over on Court TV interviewed him after Turtle Boy. But anyhow, that was one of my takeaways, is that there really wasn't any direction. They didn't know that they could tell the judge, and there were stronger members of the jury that said, no, we're not going to tell the judge that. And the not so personality strong jurors kind of consented, even though a couple of them said, shouldn't we tell the judge that we, have unanimously decided not guilty on counts 1 and 3? But the court here, the federal court in Boston, is saying, no, it's the form is there for a reason. And to be honest, we're going through this fairly quickly. We're already on page 18, but in this decision, which, yes, I did read, they're saying it's more important than that. It's not form over substance. What it is that, the jurors could have just taken a quick straw poll without deciding it. The jurors could have just taken a quick up and down the table without really delving into a fair discussion of the whole thing. So that's what they're saying here. The only verdict which can be received and regarded as a complete and valid verdict of a jury upon which a judgment can be rendered is an open and public verdict given in and assented to in open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court. And here we are in an 1831 case. Wowza.
Oh. That's recent.
200 years old.
Oh my god.
I don't really remember that.
Yeah, I don't know. Something tells me they didn't have cell phones back then.
No, and they didn't have YouTube either.
They did not. No social media.
So even if the jury's deadlock pertains specifically to count 2, their notes made no such distinction, nor did they indicate any verdict would be returned to the judge in open court as required by Mass Rule of Criminal Procedure 27A. So this is the final straw on this issue. Counsel have pointed to no case from any jurisdiction in which a private, unreported, and unrecorded vote of a jury was deemed to be a ruling capable of terminating jeopardy. In fact, the Supreme Court has held that it is not sufficient for the foreperson of a jury to report in open court in the presence of other jurors that the jury had voted to acquit as to certain counts. So that's a big hole in the case. So that's pretty much decided. Here, even assuming that the jury did take a vote to acquit petitioner on counts 1 and 3, there is no basis to conclude that any such agreement was final. Unlike one of the cases that they deep dive into in this decision, any such agreement was not reported in open court in the presence of the other jurors, casting further doubt on the finality of that vote. And they go deep dive into another case that is helpful to the position that there should not be a habeas corpus. Counsel for Karen Reed has not pointed to any case from any court where a federal court considering a Section 2241 petition has either undertaken its own voir dire of a state court jury or ordered a state court to do the same. So now we're switching topics to whether or not there was a double jeopardy violation to, whether they should poll the jurors. And this court is saying no. To begin, an injunction directing the state court to conduct a voir dire of the former jurors would implicate substantial concerns of federalism and comity. While these concerns may be somewhat mitigated if this court itself conducts the voir dire, such a process would nonetheless represent a substantial intrusion by a federal court into the functions and role of the jury. And so they go on this, and they give many, 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 many reasons why this court believes that a voir dire should not be conducted, even assuming that the many practical issues with a voir dire could be resolved, and even putting the federalism and comity issues to one side. There is a more substantial problem with the petitioner's proposal. It runs directly contrary, this court believes, to long-established principles that generally prohibit any examination of the content of juror deliberation. Boy, we've been over this bridge so many times, haven't we? I mean,
all we needed is a green and a red button. All right, juror, this is your pin. Input your decision. All right, we got everybody's input. Oh, we didn't agree on count 2. Okay, let's do this again. You deliberate, and then we'll vote again.
Yeah, I agree with you, but the court said, nah. This is a highly sensationalized prosecution that has been the subject of exceptional public scrutiny, not only locally, but nationally. I mean, yeah, we've seen, people from all over the place will follow this. We have people from 52 countries following our coverage. For a number of reasons, it has also proved to be universally divisive. There is a strong likelihood that jurors would be subject to harassment, public pressure, and social coercion were the court to order a post-trial voir dire that explores the viewpoints and votes at some length. More than 8 months after the conclusion of the trial, the jurors' willingness to speak honestly about their deliberations would surely be compromised. I think the court is cracking its second beer on this one because, it's been 8 months. Why bring them all back? If they wanted to speak honestly and frankly about their deliberations, they would have done that. I mean, I've said it many times, but I mean, within days after the verdict in the Alex Murdaugh case, 3 of the jurors were on Good Morning America. I mean, so there's that. There was one other quote I wanted to get to, and that is, for all of these reasons, the court concludes that a federal court voir dire of the state court jurors, a voir dire that would necessarily subject their private deliberations to intense public scrutiny, is probably unlawful, certainly ill-advised. That's pretty strong language. But in any event, under the circumstances presented here, the court concludes that it is not necessary to reach the issue, even assuming that a post-trial voir dire elicited evidence strongly favorable to the petitioner, such as an attestation from each juror that the jury voted unanimously to acquit the petitioner on counts 1 and 3 before being discharged. Her claim would still fail. As noted, an acquittal requires a ruling that the prosecution's proof is insufficient to establish criminal liability for an offense. A private, unrecorded jury vote is not a ruling and therefore not an acquittal. So it does seem that they're restating the same thing over and over again, but I mean, they're approaching the analysis from different edges, and we could be here until Christmas, going over the different analyses. But accordingly, the court declines to order post-trial voir dire of the individual jurors in the initial trial of this matter, and they're saying no, we're not going to allow either the federal court or the state court to go ahead and voir dire. Now, you might ask, could this be appealed? I'm glad you asked that. Here's a memorandum and order on motion for a certificate of appealability. And the point that is made here is by the same judge. You can't appeal this ruling unless you have a certificate of appealability. So we go to the bottom where it says that to appeal a final order of an habeas corpus proceeding that contests the validity of a state custody, a petitioner must first obtain a certificate of appealability from a circuit justice or a district court. This is the kind of stuff that made me want to go to law school. What does that mean?
See, that was my exact thought.
What are the intricacies of federal law and procedure? And, we study this stuff for years in law school. What is the procedure? But that's the procedure. You've got to have a certificate of appealability from a circuit justice or a district court. A certificate of appealability will issue only if the petitioner has made a substantial showing of the denial of a constitutional right. This standard is satisfied by demonstrating that jurists of reason could disagree with the district court's resolution of the petitioner's constitutional claims, or that the jurists could conclude the issues presented are adequate to deserve encouragement to proceed further. So while this court, the federal court in Boston, on a beautiful harbor, waterfront, even though they've just spent 28 pages telling us, from multiple different angles, why her petition should be squashed, denied, trashed, shredded, they're now saying, well, you know what? If you take a look at what she has done, petitioner has made the necessary substantial showing of the denial of a constitutional right as to all claims. Accordingly, a certificate of appealability is granted as to all claims. And so there you have it. That's the decision. And they're saying, all right, she can appeal. Now, there's 2 levels of appeal. There's the Court of Appeals, and then there's the Supreme Court. And as we record this episode, the trial is scheduled 2 weeks away. So I said it before, I'll say it again. The courts just don't act that quickly. What did attorneys think of this? So what do lawyers think? Anywhere you go in Massachusetts, whether you go to lunch with a bunch of other lawyers or you're, waiting for your motion to be called, they'll get into a conversation. They'll say, what did Lawyers Weekly say? Or have you read that article in Lawyers Weekly? Massachusetts Lawyers Weekly is the journal, the record of what's going on in the legal profession in Massachusetts. And so the publishers of Massachusetts Lawyers Weekly asked attorneys, what they thought. And here are the results of that poll in Massachusetts. The question was, will Karen Reed succeed in her bid to have a federal judge bar her from being retried on 2 of the charges against her based on post-trial reports of jurors' deliberations? So 89% of the people in this poll, attorneys all, said no. Only 11% said yes. So
even though 89% of them voted no, do you think that it's still possible that a good portion of those attorneys still would have done the same thing had they been in Karen Reed's attorney's position?
I don't know.
Do you think it's just a waste of time, or do you think that it's just like being a proper attorney trying to get in everything?
Due diligence is the word. Yeah, due diligence. I think, when I first read after the Supreme Judicial Court appeal did not succeed, and her appellate attorney Weinstein said, I'm thinking about doing a habeas corpus. He said, I'm thinking about it. He didn't come right out and say, I'm going to do it. Then a couple of weeks later, he did file the petition for habeas corpus. I don't think he would have actually had to have done it, but I think, with the controversy that this case has generated and the fact that there's a very adamant proclamation of innocence, that he had to do it. And Lawyers Weekly pointed out here that it's not a scientific poll. It's just a publication that we all read. And I did not participate in this survey. I don't know. I get kind of busy. I probably should have. But, they're readers who are all attorneys and all know the law, presumably. Many of them have been practicing law for many years. 89% said no. They didn't think the habeas corpus was going to be successful. I had my doubts, but that's me.
Would you have voted no?
If
you had to pick yes or no?
Yeah, I probably would have voted no. All right. Now, Proctor.
Dun, dun, dun.
If you were married to Michael Proctor and he said the things that he said, well, Mr. Proctor's wife has come out very strongly in favor and saying that people are being unfair to him. Here's an article from Boston.com. Michael Proctor's family releases a statement, accuses Karen Reed of maligning embattled trooper after exhaustive investigations at both the state and federal level and a grand jury. Only one person has been charged with a crime, the defendant, Karen Reed. The trooper's wife said.
That is very bold claims for someone whose husband is being investigated for malpractice in his position. It's like, well, there's only one person on trial. It's like, it's a little bold to say.
The family of embattled Massachusetts State Police Trooper Michael Proctor, whose crude texts about Karen Reed cast a pall over her first murder trial and put his own career in jeopardy, has spoken out for the first time. Proctor's wife and sister released statements Thursday accusing Reed's lawyers of maligning the poor investigator to deflect from overwhelming evidence pointing to Reed's alleged role in the January 22nd, 2022 death of her boyfriend, Boston police officer John O'Keefe. The Proctors urged members of the public to actually look at the facts of this case, noting a federal probe into the state's handling of the investigation recently concluded, with no arrests or charges announced. After exhaustive investigations at both the state and federal level and a grand jury, only one person has been charged with a crime, said Elizabeth Proctor, the trooper's wife. And there he is on the stand during the trial in Norfolk County Superior Court in beautiful Dedham, Massachusetts. No, that's how outsiders pronounce it. It's not Dedham, it's Dedham. We know all this. Reed, 45, is accused of backing in her SUV into O'Keefe while dropping him off at an after party hosted at a fellow Boston officer's home in Canton. While prosecutors say she struck O'Keefe and left him for dead, the defense maintains O'Keefe walked inside and was promptly beaten, attacked by the homeowner's dog, and ultimately dumped outside in the snow. We have all this background. During his testimony, Proctor admitted he dehumanized Reed through texts calling her a whack job. See you next Tuesday. Can I say that?
Yeah, you can say see you next Tuesday.
Okay. Making light of her Crohn's disease, joking about looking for nudes on her phone, and expressing hope she would kill herself. Who among us has not said something regrettable in moments of stress, shock, or sadness? And how would you feel if the contents of your personal phone were questionably released to the public without full context?
What is the full context of saying that you're looking for nudes of someone that you know in real life? And how are they standing by this guy? Like, obviously, we don't know what's going on in their lives, and victims of abuse perpetuate abuse, but at the same time, it's just like, how are these people staying so loyal to a man who could not even stay loyal to his wife? It's not some random internet person. Even he knows Karen Reed, and he's joking about finding these inappropriate pictures on his phone, and these women are defending this behavior.
Well, but Lainey, Elizabeth Proctor
said emotional.
Elizabeth Proctor said their family has been tormented in the years. So
and he should stop tormenting them. He's the torment on them.
When I get out of high school, here's how I feel about that type of language. And she says, who doesn't use that type of language? When I got out of high school, I wasn't going to go to college. I was going to be rebellious. And so I worked for about a year and a half in a warehouse, loading and unloading tractor trailer trucks and, interacting with the tractor trailer truck drivers and riding a forklift. I mean, I was out of high school maybe 3 or 4 weeks, and they said, here's a forklift, go unload that. I'm like, what? Now you've got to have all kinds of layers and levels of, certifications and approvals and all that gobbledygook. But then I was maybe 3 or 4 weeks out of high school, and they said, there's the forklift, up, down, right, left. Okay. So I'm driving a forklift, loading and unloading tractor trailer trucks. And you can imagine the language, a lot of F-bombs, a lot of SH bombs, but I'll tell you this, there were women that worked in the business office, and they were in and out of the place. And if we had ever said the kind of stuff that Michael Proctor's accused, we would have been fired immediately. I'm telling you right now, the guy who ran the place was a crusty old guy, but he was very protective of the women in the business office. And any kind of a comment that was a little bit, out of something that any normal person would tolerate, you got a talking to at the very least. But this kind of stuff, I mean, I didn't even know what a balloon knot is, I'll be honest. You would have been out of there. You would have been out on your butt, flipping burgers next door at the Burger King. Anyhow, all right. Okay.
But it's in those moments, if it's a result of emotion, you're not like you said, it's just like there's no excuse for using that type of behavior. And it's insane that these two women are defending him because he's clearly shown that he can't respect Karen Reed. If he can't respect her, why is he going to respect you, whether it be his wife or, her sister? Like, the situation is just insane. And,
I don't really care that it was his own personal phone because he was on government time. He was on the taxpayers' dime. And the Massachusetts...
It was related to work.
Yeah, and the Massachusetts taxpayers have already been besieged upon. There was a huge controversy over the fact that, and it's not even alleged, so I'm not going to couch my language. It was proven that a lot of Massachusetts State Police troopers were putting in for overtime, and calling it in, staying home, going to the Sox game, whatever, and so. The Massachusetts State Police troopers know that they were already under a great deal of scrutiny. So for him to be talking like this and saying, she's a whack job and I hope she offs herself. No.
Does she want to get pulled over by someone who's sending text messages out like this? Because if she's excusing it in him, she's basically excusing it for herself. What's her situation going to be when someone pulls her over or something happens with her and then people are treating her case the way that Karen Reed's case is being treated?
Well, but you have to remember that, there's professional courtesy had she been pulled over, and as soon as they realize who she was, okay, hon, see you later. That's how that goes. That's how that goes.
The special stickers on the car.
And tell me I'm wrong down in the comments. Tell me I'm wrong down in the comments.
The special
I know
friend
I'm
of
not
police
wrong.
card.
All right, because there was a case in Massachusetts a number of years ago where a district court judge had been pulled over for drunk driving because he was driving drunk, and he was driving like he was drunk. And he pulled one of these, do you know who I am? And that was an extraordinary circumstance. But yeah, they weren't impressed by that. Anyhow, let's finish this out. Lizzie Proctor said their family's been tormented in the years since O'Keefe's death. Unfortunately, we know that by speaking out, more harassment will be unleashed on our family. But we can no longer stand by and silently watch Michael's character be attacked and disparaged so unfairly. Soon after Reed's mistrial, state police suspended Proctor without pay, pending an internal affairs investigation. Proctor has also faced a series of closed-door trial board hearings regarding his allegations of misconduct, including another session slated for Thursday. Well, okay, as we record this, that session is now gone, and the remainder of the procedure is that now 3 higher echelon troopers have been assigned to deliberate and come up with their final recommendations, and then it is up to the chief of the Massachusetts State Police to determine what to do. But I don't know. If I was a betting man, which I'm really not, I would say that we're not going to be seeing a whole lot more of Mr. Proctor.
You think that they're gonna X him out? You think it's just because he's like a liability? I'm convinced that he's gonna stay.
Oh, well, then we have a difference of opinion here on about the law. I don't know. How much do you want to bet? A coffee?
Oh my God, I'll bet you a coffee on that. But the thing is just like you have a good point in saying that like they will, cut him out, because if they don't, there's going to be riots and protests.
I like the green tea latte over at Starbucks. None of this Dunkin' Donuts stuff. I like the Starbucks stuff. So you better save your pennies.
Oh, you got to get me you're going to owe me a venti strawberry refresher.
Oh, audience, you are witness to this bet. So, all right. But wait a minute. Are we clear? I'm saying he's gone.
I'm saying that they're going to keep him. I hope he's gone, but I think that there's going to be a crowd of people with a bunch of signs saying, get Proctor out of here.
But you're saying they're going to keep him anyhow.
I'm saying that logically the best thing for them to do for their image would be to get rid of him. I think that there's a non-zero chance that they're just going to keep him anyway.
Interesting. Well, all right. So we had some other stuff here about Mr. Proctor. And the next motion, there were a flurry of motions that came up, and we only were able to do a couple of them, and we were criticized because we did an episode on a Wednesday, let's say. No, we did an episode on a Tuesday, let's say. And as usual, I forgot to turn my phone off. So we did an episode, which was just a throw together episode of our viewer comments. And right before we went on, I checked the docket, and there were 41 different documents that have been filed. So there was no way for us to get through them all. And so I just read down the docket. Oh, but did I get blasted? All I did was just read down the docket because we didn't have time. And I got blasted. You have to read them. Well, yeah, duh. So now we've had a chance to read some of them. And I think some of them are quite interesting. This one is a motion in limine to exclude false and irrelevant statements of Michael Proctor, and it's brought by the defense. And no, they're not seeking to exclude the bad words. On June 10th of 2024, Trooper Proctor testified as a witness for the Commonwealth. And on direct examination, he testified that while the examination of Mrs. Reed was ongoing, he sent text messages to other members of the Mass State Police about Attorney David Yannetti, saying, I hate that man. I truly hate that man. On redirect, which occurred on June 12th, Trooper Proctor was asked to clarify why he disliked Mr. Yannetti. He seems like a nice enough guy. I've never met him, but he seems like he's pretty calm compared to some other attorneys. During his response, Trooper Proctor falsely claimed that Mr. Yannetti had gone to the parking lot of a school where Trooper Proctor's sister worked the day before in order to harass her. Trooper Proctor falsely claimed, apparently referencing rank and false hearsay, as Trooper Proctor did not claim to have been present when Mr. Yannetti was there, that Mr. Yannetti had been asked to leave the parking lot but refused. Trooper Proctor also falsely alleged that Mr. Yannetti asked someone at the school if Michael Proctor's sister was working there that day. He testified that Courtney thought she was being served, although there was no evidence that Courtney Proctor ever saw Mr. Yannetti that day. At this point in the testimony, defense counsel objected, and the court requested that counsel approach at sidebar. After consulting with counsel, the court correctly concluded that Trooper Proctor's testimony regarding Mr. Yannetti should be stricken from the record and instructed the jury to disregard the testimony. After the trial ended in a mistrial, defense counsel received a copy of a Canton Police Department incident report that was filed in relation to Mr. Yannetti's presence in the school parking lot on June 11th of 2024. The incident report directly contradicts every false allegation from Trooper Proctor's testimony on June 12, 2024, and shows that Trooper Proctor made completely false statements under oath. The incident report states that the principal of JFK Elementary School contacted Patrolman Eric Kasaskovich, the school resource officer, to make him aware that Mr. Yannetti and Brian Loughran, remember him? He was the tow truck, not the tow truck, he was the snowplow operator, had been seen in the school parking lot that day. The principal informed Patrolman Kasaskovich that Mr. Yannetti and Mr. Loughran were not approaching the school students or staff, and that she only wanted to make Patrolman Kaskovich aware in the event that things escalated or hit social media. Patrolman Kaskovich responded to the school and spoke to the principal and others at the school. He detailed that it was reported that neither individual ever approached the school, students, or staff members. Patrolman Kaskovich observed Mr. Yannetti, Mr. Loughran, and two individuals pull in the parking lot, talk for 5 to 10 minutes, and leave the parking lot in their separate cars. Patrolman Kaskovich wrote that none of the four ever pointed at or approached the school, the staff, or students. Trooper Proctor's claims that Mr. Yannetti was asked to leave, refused to leave, and inquired about Courtney Proctor were all completely fabricated during his sworn testimony. So that's just an interesting little aside. One other motion, I know our time is kind of limited here, but one other little aside I wanted to make. I did incorrectly say, because it was docketed incorrectly, that it was the state that brought a motion in limine to allow counsel to state grounds for objections to promote judicial economy and efficiency and to adequately preserve issues. So what's important about this motion for people that remember watching the first trial was that Judge Cannoni asked, and this is a matter of preference for different judges. I've seen different judges do it different ways. She asked that the grounds for objections not be stated in open court. If you have an objection, just say objection, and I'll either allow it or overrule it. If there's a controversy, we will then have a sidebar and determine it there. Well, two arguments against that. One, that really slows the trial down to constantly be going to sidebars, because there were a lot of sidebars. Laney, if you were a juror, and I've always wondered this, if you were a juror, and I know there's an instruction to overlook it, but I don't think jurors listen to that. If you were a juror and you were taking time away from your life for 2.5 months, and the attorneys are constantly running over to the bench, how would you feel about that?
I wouldn't make it through one day of court personally. I know myself, I'd be losing my mind if I had to sit there and watch all of that.
That, and the other thing is in this motion, the defense argues that, you know what? It could be viewed, if we lose this case and Karen Reed is convicted, a lot of our objections, aren't on the record. If I have a legitimate, valid objection to an exhibit coming in, maybe there's speculation, maybe it's bald hearsay. If I haven't been allowed to state the grounds for my objection on the record, I may be viewed, and they cite some cases, I might be viewed as having waived that objection. And so the fact that that evidence went in, and the fact that the jury considered, purely objectionable evidence, I've waived that argument, and that may really impact the possibility of a successful appeal. So those are the arguments that they made in this motion without reading it all word for word. I think they're valid arguments. And I think the trial would go more smoothly, and also the defense would be allowed to keep a record. Not that this court wants that for appeal. So those were a couple of the motions. I know there were a lot of them. There were 40 different documents, 41 different documents. If you really want us to go into one, those were the two that people actually mentioned to us. But and I'll close my thoughts. I always ask you what your closing thoughts are, but my closing thoughts are, if you want us to go through some of the other 41 papers that were filed on March 11th, let us know, and we will. And the other one is, who's right, me or Lainey?
Yeah, let us know what you guys think. Are they going to keep Proctor?
Is Proctor going to be in, or is he going to be out? And also, are they going to let him in or out before the trial? Will they take forever to deliberate, or will they not take forever to deliberate? So who's right? Who's wrong?
Bro, don't even bring up that they might just procrastinate on deliberating. I don't even want to think about that possibility. I want to know now so we can get it over with.
So we have 52 different countries on our list now. We don't have time to go over them today, but we have had comments from people in 52 countries around the globe, and we've listed them all. We'll do it again in the next episode. But if you're from a country that is not on the list, even if you are on the list, let us know. Let us know that you're following us, and thank you. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.